We opened our doors for business in London over 40 years ago, and we're still trading on the same values now as we did then. Professional, dedicated, and trusted. We are the MECO Group.
I'm talking about lay-time and demurrage again today, and in particular London Arbitration 1229, just reported in May 2019's LMLN. And it's an instructive case on areas where charterers might be able to reduce a demurrage liability, and also raises points which can assist with drafting future charters to also reduce future demurrage. The case, like a lot of others, is set at the Kavkaz OPL, a weather-battered location on the Kerch Strait between the Black and Azov Seas, where Russian agricultural produce is brought down in barges and loaded by floating cranes onto motherships for ocean voyages there. In this case, the vessel being chartered on a Synacomex 90 amended form. Delays due to cargo or crane supply problems and bad weather are very common at Kavkaz OPL, and this can lead to significant demurrage claims. In this particular case, charterers did the usual process of trying to attack the owner's lay time calculation at its extremities, at its commencement and ending, and also in the middle, trying to discount particular periods under the rules relating to interruptions and exceptions to lay time. How they did so is instructive, albeit charterers were ultimately unsuccessful and in full, and had to pay, it seems, the full demurrage bill. As for the starting of lay time, charterers were not happy, as after a couple of weeks waiting at a waiting place, the vessel berth and its holes were found not to be clean. The charter provided for the time thereafter until cleaning was done to be accepted from lay time. There was no issue about that, but what about the 2 weeks earlier, while the vessel had been waiting, seemingly, as the charterers put it, with dirty holds? Like other modern charters, such as the GenCon 1994, the Synacomex 90 form allows a notice of readiness to be given from a usual waiting place, provided that the master gives a warranty at that time to the charterers that the vessel is in all respects ready to perform her cargo operations. This is what happened in this case. The effect was that the time waiting to berth counted as lay time, and this led to the large demurrage bill that charterers faced in this case. The charterers then tried to challenge this notice of readiness because if they could prove it was invalid, that would of course put the waiting time to owner's account. The way they did that was they tried to mount a factual attack on the necessary qualifications for a valid notice of readiness from there. They argued that the vessel was not at a usual waiting place, and they raised issues as to whether the place of intended loading was actually unavailable at the time the notice of readiness was served. Those points were decided on the factual evidence by the tribunal, and charterers were unsuccessful in those challenges. It seems also, and this is somewhat unclear from the report, there may have been a challenge as to the master's warranty and the readiness of the vessel to actually perform her cargo operations when the notice of readiness was given. The charter, as I've said before, required the master to warrant the vessel's readiness. In these circumstances, as the tribunal ruled, provided that warranty is given, and despite some slightly confusing bespoke additional clauses in that charter, the effect of this is that provided the warranty is given and the notice is served from the required place, time will run pursuant to that notice. Here, the challenges that were made by charterers failed, and looking at other case law, it would seem that where a warranty of this kind is relied upon by owners, charterers to defeat such an NOR will have to probably show the notice was not given in good faith by the master. How they would do that is one can only assume that looking at the evidence of the condition of the holes when the vessel finally berths and is inspected, one can perhaps work back from there using expert evidence and raise an inference that the master must not have been in good faith when he served his notice, and that the holes could not have been clean at that time and to his knowledge. The case doesn't go into any detail on that, and it would have been interesting if it had done so. Having failed on those points about commencement of lay time, charterers also tried to knock out some periods of counting time from after commencement. Firstly, they tried to rely on a storm warning period or a number of storm warning periods to not count the time of those, either because such times were not weather working days, or they fell within exceptions that provided that time lost due to bad weather would not count. As a recap of the usual rules, where time is defined in weather working days, days which are not days on which loading or discharge can be done just simply never count because they're outside the definition of lay time, counting lay time days. And secondly, if we're talking about an exception, in contrast to those interruptions, the rule is that charterers must prove that time was actually lost through this accepted cause. So, for instance, if there would have been no loading anyway because of some other reason, such as absence of cargo, they cannot assert the exception to discount the time in question while it operated. In this case, charterers asserted a storm warning. They couldn't rely on that for the reason, the tribunal said, that warnings of bad weather do not constitute bad weather. You need actual bad weather. So those periods fell within neither of those two types of class of periods you can discount from lay time. And secondly, there was a period of an attempt to discount time when the Kerch Strait, from whence the cargo would come in barges, was itself closed. In that case, charterers sought to rely on an exception, but could not do so because there were a number of other reasons why loading could not have taken place at that time. The tribunal ruled they would have to disprove the operation of all those matters and show that the closure of the strait was the only reason why loading was not or would not have been proceeding at that time to accept that time. So charterers failed on both those attempts to discount the storm warning time and the Kerch Strait closures. So charterers' load port arguments got them nowhere. The vessel proceeded to a disport at Chittagong. Charterers then made another attempt to discount disport lay time, this time arguing that bad weather stopping lighters that were going to be used to discharge the cargo from reaching the vessel, arguing that that meant those were not weather working days or fell within an exception by which time lost because cargo operations could not be done would not count. The reason charterers failed to establish a right to not count time under either of those points on that occasion was that both the determination of weather working days and this exception in relation to cargo operations only worked in relation to actual cargo operations by the proper meaning of that. And what that means, or meant in this context, is the process of putting the cargo from the mothership onto the lighters and not the approach of the lighters to that position where that will happen. Because of that, neither the interruption nor the exception actually applied in that case. So no deduction again here for charterers. All in all then, a good workout on some of the principles involved, but not a good day for these charterers.